Each state handles workers' compensation claims differently. So this is how Virginia handled this situation. This worker on September 15th, 2023, it was a Friday. He had picked up, I guess, chocolate and he had loaded into his delivery van or vehicle at the company warehouse. And then I guess he was done for the day. He drove home. And then on Monday, he was gonna basically drive off from his house and start delivering the things he picked up. So what ended up happening about 5 hours later after he'd gotten home, he realized, oh, this weekend's gonna be really hot. So he had chocolate in his work truck. The work truck's freezer was non-functional. He knew that that was the case. So he was like, I don't want this to all melt. So he went and his intention was to schlep the chocolate from his work truck to his refrigerator, his personal refrigerator, and then thus saving the chocolate from melting. But what ended up happening was while he was grabbing a tote full of the chocolate, his left foot slipped, his left knee struck the ledge on the back of the truck, and then, he suffered a work injury. He injured as well. He wanted to suffer a work injury, or he wanted to pursue a work injury for that injury to his left knee, but Virginia denied it. And Virginia denied it because they said it wasn't in the course of employment, it wasn't a work injury. He's at home. It's 5 hours after he clocked out. Being at home, there's no requirement to put the chocolate in the back of his home, so therefore they denied it. So how might Ohio handle this? Ohio applies, they apply something called, they determine whether it's in the course of employment, and usually that's contemplating the time, place, and circumstances of where the injury occurs and how it occurs, and whether the circumstances are consistent with the contract for hire. So, i.e. is moving chocolate from your work truck to your house, is that really consistent with what the job is? If you're a delivery driver, is that really what you do? Not really. So the Ohio might look at that, and they might look at it like Virginia and be like, dude, you weren't working at the time. But then in the time and the place and circumstances, maybe not. And then they're looking arising out of employment. And so this looks at the proximity and the benefit of the control of the employer. So that's the PCB. So proximity to place of employment. He's at his house. I don't know. I'm assuming he doesn't live at work. The benefit to the employer. There's a benefit to the employer. The chocolate didn't melt. But the control, the employer has no control over the guy's house. So based upon this, I think Ohio may also deny this individual's claim. It's kind of no good deed goes unpunished kind of situation, but it is what it is.